Welcome back to Unfair Housing. I'm Alicia Magazoo. Thank you for joining us this week to continue our discussion on contract sales and the impact they had on housing equity, neighborhood segregation, and the stripping of wealth from Black families. We'll start today by talking about a courageous group of Chicagoans who banded together to fight back against the predatory practices of white solicitors in two Chicago neighborhoods and the white allies who worked along with them to seek justice. The contract sales schemes perpetrated by numerous white solicitors in Lawndale, a Black neighborhood created through blockbusting practices on the west side of Chicago, caught the attention of a local Catholic church. While many Catholics had been heavily involved with local violence against Black families moving into white neighborhoods, believing the church supported segregation, there were some who felt racial oppression was an injustice. One such Catholic was Monsignor John J. Egan. Egan was appointed to Lawndale's Presentation Parish by Cardinal John Patrick Cody, who was set on silencing social activism by Catholic priests. But as you'll soon see, he misjudged Egan's influence. Egan took his appointment very seriously and became completely committed to getting to know the West Side Lawndale residents to help organize and build a community. To get started, he sent priests into the neighborhood daily to learn the community's needs. A young priest in training inspired by this activity was John McNamara. In the summer of 1967, McNamara led a group of young people who rented 2 apartments in the Lawndale neighborhood so they could get hands-on experience with what it was like to live in one of Chicago's most impoverished neighborhoods. The group consisted of 2 Jesuit seminarians, including McNamara, and 12 college students. They went from house to house getting to know the neighborhood and listening to residents share what issues they faced. The group heard many grievances, including complaints such as expectations to pay taxes, yet services were not provided in return for paying those taxes. There were no parks for Lawndale children to play in, and garbage was rarely collected. Both were matters McNamara and his team were able to help remedy by piling trash on the steps of City Hall and busing Black children to play in Mayor Daley's all-white neighborhood playground. But those matters were not significant enough to mobilize the residents in Lawndale. It wasn't until they heard about housing issues that their work really began. Rents were high, yet housing was substandard. When tenants reported code violations, they went ignored or were dismissed in court. But most notable was the exploitation of Black home seekers who purchased real estate on contract. Take, for example, the Collins family. They purchased a home in Lawndale on contract from Irwin Spector for $25,500 with a down payment of $1,500. And the rest was to be paid over 19 years at an interest rate of 7%, which at the time was the highest interest rate allowed by law. At the end of the contract, the Collins would have paid nearly $45,000 for their home. Spector purchased it for only $14,000 the same week he sold it to the Collins, which meant he stood to make more than $30,000 off one family. Turns out, Spector later admitted publicly he sold contracts to 50 other families under similar terms. Now, had the Collins been able to purchase the home with a mortgage and at a fair market purchase price, the total cost of the home would have been just shy of $21,000. This meant the Collins were poised to pay a Black tax of over $20,000 to purchase their home on contract, which of course also came with greater risks like we discussed in our last episode. The Collins story resembles many others in the West Side Lawndale neighborhood, where the average home purchased on contract was marked up approximately $20,000. At least half the real estate purchased there was sold on contract. Based on the typical terms in installment contracts, residents in Lawndale were paying upwards of 35 to 45% of their income on housing. Meanwhile, the Federal Housing Administration, or the FHA, was offering programs that capped payments at no more than 25% of a household's income because anything more than that was considered a financial burden for the family. But McNamara learned mobilizing around ending predatory installment contracts came with risks. This form of home purchase arrangement had made many powerful Chicagoans very, very wealthy, including those close to the mayor. When McNamara took the idea to his superiors, he was warned to steer clear. Despite this warning, McNamara persisted. In his view, you don't shy away from something just because it's too difficult. So he and his team spent hundreds of hours researching sales records for every building in Lawndale. But to accomplish the change they wanted, data collection wasn't enough. What they needed was buy-in from the community. So they set up meetings. But what they soon realized is people weren't so enthusiastic about publicly admitting they had been scammed. Thankfully, Ruth Wells mustered the courage and shared her story about how she had purchased a property for $23,000 from Mo Foreman, who had purchased it for just $13,500 the month before. Even with all the improvements she and her husband made, the current appraised value was only $14,750. When the contract was half paid, rather than help them secure a mortgage as originally promised, he slapped them with a $1,500 fee without explanation. Wells' story inspired others to share their experiences, and the Contract Buyers League of Lawndale was born. The first action taken by the Contract Buyers League, or CBL, was to approach Foreman and request a reduction on the contracts in the Lawndale area. And not small reductions either, but upwards of $10,000 to $15,000. But negotiations took time and effort. The group picketed outside Foreman's office and visited his neighbors, sharing what he had done. To their surprise, they were not met with hostility, and in some cases were met with sympathy and fellowship. In time, the group was able to secure a written message from Foreman indicating he would renegotiate the contracts he held partial stake in, but the promise turned out to be empty. But what was accomplished through this effort and Foreman's response was a CBL of 1,000 members strong. CBL members continued to picket around the homes and places of employment of contract sellers, as well as in front of banks that worked with those contract sellers, to encourage renegotiations of their installment contracts. These tactics had little impact on the status of their contracts, but what it did do was bring attention to the situation. Fewer and fewer Black residents were interested in properties sold on contract, which meant demand was diminishing, which also meant contract sellers were slower to evict buyers who missed payments to avoid their properties sitting vacant. The power of mobilizing also brought with it a true sense of community. Members became so connected, individual settlement offers were turned down unless all their neighbors' contracts were renegotiated as well. Following the assassination of Martin Luther King Jr. in April 1968 and the unrest that followed, the activity of CBL members began to gain widespread attention. See, up to this point, contract sellers leaned on the explanation that America enjoys a free market where prices are set at what people are willing to pay. But the attention brought to the dual housing market by CBL began to alter this popular opinion and helped them gain supporters and sympathizers outside of Lawndale. These outside supporters included John O'Connor, the owner of a Chicago trucking firm, and Judge Harold Sullivan, O'Connor's brother-in-law. The two, along with McNamara, helped the group assemble a legal team. Government officials also voiced support for CBL, including the Attorney General for Northern Illinois, Thomas Farran, and Representatives Robert E. Mann and James W. Carter, who participated in public hearings on the matter. Chicago's religious leaders took notice of the oppression in Lawndale as well, such as Rabbi Robert J. Marks, who compared the conditions in neighborhoods like Lawndale to the hate and violence experienced by Jews. Even media sources began showing support for CBL, publishing stories encouraging contract sellers to renegotiate to help boost economic stability in Black communities. There was another group of outsiders who took notice of CBL's activities when they too realized they had been taken advantage of by contract sellers. Take Sidney Clark, for example. Clark lived with his wife and 2 children in the South Side, an area within Chicago where Blacks were allowed to live. He was a hardworking, successful police detective who, like so many others like him, wanted a stable home for his family. He purchased a new home on contract from Universal Builders. Not long after purchasing, he realized his new home was very poorly built. The walls were thin and began to crack, and the basement was left unfinished. Over 1,000 homes were sold to Black buyers under terms similar to Clark's. Upon realizing this connection, Clark began mobilizing his neighbors to join CBL. Around this same time, CBL was planning a new strategy because their picketing and legislative efforts had not produced widespread results. In December 1968, CBL, along with its new Southside members, decided to implement a payment strike. Since many properties bought on contract had underlying mortgages, CBL was certain the inability for contract sellers to make their own mortgage payments would encourage new renegotiation discussions, particularly given the advocacy efforts by CBL members to discourage other Black buyers from purchasing homes in these neighborhoods on contract. CBL members were also ready to defend against the consequences, which was surely to result in families getting thrown out of their homes for non-payment. Over 600 Black families decided to withhold their monthly payment, and when they could, even some renters began to withhold their rent in solidarity. Not long after the strike was initiated, it made national news. But contract sellers did not respond to the payment strike with contract negotiations. Instead, they armed themselves for a court battle. The Westside Contract Sellers of Lawndale hired Irving Block. An attorney Mark Satter battled against many times. And Universal Builders hired Bert Weizenfeld and Michael Turoff, the son of one of its co-owners. CBL armed itself as well, securing as counsel Thomas Budell Jr., a recent graduate of Harvard Law School, and Tom Sullivan, a well-known Chicago litigator from the firm Jenner & Block, which, after much negotiation, decided to offer services to CBL at no cost. Their ammunition? The recent U.S. Supreme Court decision in Jones v. Mayer, a case brought by a black prospective buyer against a construction company that refused to sell him one of its new homes because of his race. Prior to the decision, it was well-followed law, Section 1982 of the Civil Rights Act of 1866, only barred the government from engaging in housing discrimination, not private citizens. The basis for this new interpretation came from the congressional intent behind the law's passage, which focused on the 13th Amendment's purpose, to ensure those who were previously enslaved did not face unequal treatment upon gaining their freedom. The court put particular emphasis on the explanation by the law's sponsor, Senator Lyman Trumbull, in which he stated all discrimination against the black man must be destroyed or else the 13th Amendment amounts to nothing. The court likened the creation of the ghettos through racial discrimination to a relic of slavery and reasoned a black man should have the freedom to buy what a white man can buy and live where a white man can live, or else the 13th Amendment offers an empty promise. In both complaints filed by CBL members, one on behalf of the West Side buyers and the other on behalf of the South Side buyers, the arguments mirrored the reasoning in Jones v. Mayer, essentially arguing the contract sales practice that charged black buyers a higher amount than white buyers placed different values on each's purchasing power, essentially establishing a race tax. And they argued the tax didn't just apply to the contract sales in question, but also to the circumstances that created an environment for contract sellers to take advantage of black home buyers, highlighting unequal neighborhood amenities and services, the separation of neighborhoods, inferior schools, and so on. Early attempts by the contract sellers to dismiss the cases were shot down by Judge Herbert Will. He took particular issue with the argument the contract sellers could not have discriminated against black buyers because there was no evidence or claim the sellers would have sold to white home buyers for less. Judge Hill found it ridiculous to claim the Civil Rights Act applied only if injustice impacted a single group. Even the U.S. Justice Department supported CBL's argument and filed a brief supporting the case against the West Side contract sellers. Things were really looking up for the group. However, it wasn't all wins for CBL. Like in so many other cases brought by contract buyers, where the court deems the cases were not appropriate for claims of fraud or breach of contract or duty, the same was true here. Judge Hill agreed with this argument brought by the Contract Sellers Council, so the cases proceeded only on the civil rights claims brought by CBL. Not long after the lawsuits were filed in January 1969, Universal Builders struck back against 60 Southside buyers by filing evictions under Illinois' Forcible Entry and Detainer Act. The company felt it was being unfairly attacked because, in its view, it was simply offering housing to those who otherwise would not have access. Considering some of the homes at issue were newly sold, Universal Builders also had more to lose from the payment strike, so it responded swiftly. Mounting eviction cases to defend, along with battles in the civil rights cases over CBL's intentional violation of the law, eventually led to both the South Side and West Side CBL members resuming their payments in March and April 1969. With the agreement, a portion of the payments would be set aside in an escrow account for the buyers should they win their cases. But even with this agreement in place, some contract sellers filed evictions anyway. One of the families facing eviction was Chester and Julia Fisher, who were represented by public interest lawyer Marshall Patner. The Fisher case prompted Patner to develop a new legal strategy for defending forcible entry and detainer cases, which at this time did not allow a contract buyer to raise any defenses related to why they did not make their payment. All that mattered was whether the contract buyer received notice and whether they had made their payments. Patner believed the Illinois law was unconstitutional on the grounds the inability to raise defenses was a violation of due process and equal protection under the law, which is the argument he made on appeal after his defenses were held from the jury and the Fishers lost their case. Other CBL members liked this new legal strategy because it finally gave them the opportunity to tell their side of the story. So the payment strike resumed in July. Approximately 261 families faced eviction, and these cases were appealed to challenge the forcible entry statute. However, CBL members faced another barrier to telling their stories in court. They were charged uncharacteristically high bonds to file their appeals. The typical bond for a matter involving a $200 per month delinquency was between $2,400 to $3,000, but the bonds for CBL members were set at $5,000, some even reaching $7,500. With 261 families facing eviction, posting bonds at these sums for each case would quickly drain the accumulated donations CBL had acquired through their advocacy and fundraising efforts. Outside the courtroom, CBL was making great strides with gathering supporters and donors for fighting their injustice. Upon hearing details from CBL members regarding their experiences, the Society of Jesus made a $100,000 donation to assist with posting bonds. Shortly after, the U.S. Jesuits donated $150,000 to the cause. In April 1970, the Illinois Supreme Court ruled in the Fisher case CBL members should be allowed to raise defenses that are relevant to their evictions. However, the decision was only impactful for cases in which contract issues were raised at the trial court level. The ruling, of course, also did not guarantee the defenses raised would be successful. Thus, it was likely the trial court judges would continue to rule in favor of contract sellers, and evictions would continue, putting CBL members out on the street. The decision also did not address the steep cost to appeal. It wasn't until 2 years later, in a separate case, Hamilton Corporation versus Alexander, the bond matter was decided and determined biased against poor people, because current practice meant the right to appeal was based on a person's ability to pay a significant sum. As the Fisher case played out, Universal Builders moved forward with evictions and attempted to remove 2 families from their homes. One, a widow with 9 children, 8 of whom were the orphans of her late sister. The other, a World War II combat veteran. When movers began to remove furniture from the homes, CBL members showed up in the hundreds and successfully scared them off and replaced the furniture. In future attempts, the county sheriff's office countered CBL's strength in numbers by sending out nearly 200 helmeted deputies to carry out evictions. But their numbers were still no match for CBL. As one of the contract buyers affected put it, these families can't get 2 police officers to come out and investigate a burglary. And then you have one company, Universal Builders, that can get 200 policemen to do this. I think this is very wrong. Many other attempts were made to evict CBL families, each time the same result. Police were met by CBL members in the hundreds, and the eviction attempts were unsuccessful. By June 1970, the efforts of CBL led to negotiations for 106 members, which saved them an average of $14,000. Another significant win was the addition of the Federal Housing Administration as a defendant in the case involving the West Side buyers, which was later joined by the Secretary of the Department of Housing and Urban Development, the Federal Savings and Loan Insurance Corporation, the Veterans Administration, and the Federal Home Loan Bank Board, all of which had played a role in creating the circumstances that led to the contract buyers being victims of exploitive installment contracts. But unfortunately, many other families were evicted and lost everything, including Sidney Clark. He, like at least a half dozen other evictees from Universal Builders homes, saw the homes they hoped to recover burned or bombed. The longer the Southside case went on, members and supporters also became exhausted. McNamara and Egan both moved on for personal reasons after suffering health impacts, and Judge Hill resigned from the case. But CBL carried on, focusing on a new legal argument, which claimed it was discriminatory to exploit circumstances that were created by previous discrimination for the sake of economic gain. To make the legal argument, however, required an extreme amount of data that took thousands of hours to compile and analyze. With the assistance of volunteers and Andrew Gordon, a sociology student at Northwestern, who used a computer to process the data, and keep in mind that was very novel at the time, the necessary information was collected and used to show a pattern of discrimination. In court, first in the Southside case against Universal Builders, experts used it to show the existence of a dual housing market, which the contract sellers exploited. In this case, the contract buyers were also able to argue discrimination in the more traditional sense. The company had developed a neighborhood in which it sold homes to black contract buyers on the south side for more than it sold homes to white homebuyers in a different neighborhood, despite the development costs in the white neighborhood being higher than on the south side. But unfortunately, the expert testimony based on the data was excluded on the grounds discrimination is not a technical matter. Universal Builders' business practices in the white neighborhood were also excluded because Judge Samuel Perry, the new judge assigned to the case, decided the white neighborhood was too far away from the south side to use as a comparison. The contract buyers spent nearly 6 weeks making their case, after which the contract sellers presented no defense and instead filed a motion for a directed verdict, which basically asked the judge to determine the case was too weak and therefore the contract sellers should prevail. On the next business day, following the contract sellers filing their motion, Judge Perry issued an order dismissing the case. On the basis, the facts simply were the application of the law of supply and demand. In other words, it's perfectly legal to exploit a group of people who had already been harmed for one's own personal gain. Judge Perry further ruled if the contract buyers decided to appeal and lost, they would be responsible for all the costs associated with the trial. But Judge Perry's threat did not deter CBL. They voted overwhelmingly to appeal. The decision handed down by the appellate court dissected Judge Perry's reasonings, disagreeing on all accounts. Section 1982 makes it clear all citizens have the same right as whites to purchase property. The ruling further reiterated Jones v. Mayer that discrimination, whether engaged in by government or private actors, was plainly under the purview of the law. A new trial was ordered, during which the contract sellers would have to show a non-discriminatory reason for charging higher prices and setting different terms for black buyers. This ruling also prompted the West Side case to continue, which had been stayed while the South Side case went through the appeals process. In November 1975, jury selection in the West Side case began, 6 years after the case was filed. The jury was all white, 4 men, 2 women. Throughout the case, the number of defendants had grown to 150, but over time, many settled or had the claims against them dismissed. So by the time trial came around, only 6 remained. All were contract sellers, one of whom was Jay Garan, who you may recall from last week. CBL had their work cut out for them, since some of their most crucial testimony would be withheld from the jury at trial. Specifically, just as in the South Side case, the judge in the West Side case also ruled the data prepared by volunteers and Northwestern's computer was inadmissible, on the basis it might be given unnecessary weight since people feel computers are infallible. After 4 months, the case went to the jury. The instructions stated the contract buyers must show 3 things. 1. As a result of racial discrimination, a dual housing market existed in Chicago. 2. The existence of this dual market created an opportunity for the contract sellers to charge blacks more for housing. And 3, the contract sellers took advantage of the opportunity and charged blacks prices for housing that were higher than whites paid for similar properties. If these were all found to be true by the jury, the burden shifted to the contract sellers to show no part of this difference in price is due to the race of the buyer. After 2.5 days of deliberation, the jury returned with a verdict. All 6 contract sellers were found not liable for violating the civil rights of the CBL plaintiffs. The jury reasoned the contract buyers were charged the market rate, thus the circumstances of the case hinged solely on economics. However, in an interview following the decision, the jury foreman, Francis McLennan, stated his goal for this case was to clean up the mess U.S. Supreme Court Chief Justice Earl Warren made with Brown v. Board of Education and all that nonsense. The decision in the Southside case soon followed and came straight from Judge Nicholas J. Bua, who ruled in favor of Universal Builders. The decision was appealed, but the appeal was rejected. Though years of painstaking battles ended in defeat in the courtroom, the information that came to light as a result of these 2 cases became foundational for future discrimination arguments, which were used by Northwestern University's Center for Urban Affairs to challenge discriminatory practices within the federal government. Ultimately, these challenges led to the passage of the Home Loan Mortgage Disclosure Act of 1975, which required federally regulated banks to disclose the number of loans and loan amounts they were making to help address credit inequities, and the Community Reinvestment Act of 1977, which required federally regulated banks to help meet the credit needs in their communities, not just in wealthy communities. Both laws have had significant impacts on housing. But the destruction caused by contract sales wasn't a singular issue. Through the contract sales boom, as we've mentioned, contract sellers pushed repair and maintenance responsibilities onto contract buyers. Now that there was little interest in the Black community to purchase homes on contract, and more buildings became vacant due to evictions, contract sellers under these new market conditions still had no interest in maintaining the properties, even those that still had Black families living in them. So they fell into disrepair to the point where many were condemned. In 1968 alone, more than 1,400 buildings were condemned and over 3,600 families were displaced. By 1970, nearly 70% of the several hundred properties owned by Lou Fuchanis were demolished because they were uninhabitable. In 1972, another 1,682 buildings were torn down. These circumstances led the Chicago Tribune to conduct an investigation in 1973 that revealed a small group of men had organized what the paper called a massive slum operation that involved 2,000 buildings. These men included Gerald Crane, Victor Spector, Gilbert Ballin, Al Berlin, Lou Wolf, Joseph Burke, and Mo Foreman. Because the market to purchase homes in Lawndale and the South Side was no longer a source for profit, as more and more buildings in the area became uninhabitable, contract sellers hatched a new exploitation scheme. They decided to unload their remaining properties still occupied by contract buyers by selling the buildings to those buyers, but this time in a more traditional sense. To accomplish this, contract sellers helped their contract buyers secure mortgages. By now, the FHA had reversed course on its policy to refuse insurance on loans in homes in Black neighborhoods or made to Black homebuyers, and instead had programs focused on insuring loans made in these neighborhoods and to these buyers. Contract sellers saw an opportunity through these new programs to both receive the full price of their original contract and officially shift the burden of maintaining these dilapidated buildings to the contract buyers, which also left these buyers with a loan that was much higher than the building was worth. Many contract sellers even assisted buyers with completing applications for loans, and some, like Al Berlin, actually partnered with mortgage brokers to create fraudulent credit records for buyers, reducing the number of children they had, inflating their income, etc., so they would qualify for a loan. In the end, Berlin defrauded the FHA out of $250,000. Contract sellers also began dumping properties by defaulting on their loans, thus turning the properties over to the lending institutions that held their mortgages. To mitigate damages, many of these lending institutions sold the buildings for pennies on the dollar, and many times the properties were sold right back to the very same contract sellers who dumped the properties to begin with. These rundown properties then became rentals, which slumlords failed to maintain. Despite complaints filed with code enforcement regarding lack of heat, among other things, repairs were still not made, and unfortunately, as a result, several babies living in these buildings died. Rather than address the issue, slumlords instead sought out a new source of revenue. A benefit of repurchasing these dilapidated buildings turned out to be access to insurance proceeds. While many Black neighborhoods went uninsured prior to 1968, riots that year prompted the passage of the Illinois FAIR Plan, which ensured Black neighborhoods had access to fire insurance. With this law in place, slumlords had an incentive to force tenants out of their buildings so they could collect the insurance payment. Part of the scheme was to over-insure these rundown properties at amounts astronomically higher than their worth. Take Al Berlin's properties, for example. He was able to collect $350,000 when fires broke out in 47 of his buildings, which meant, on average, he was able to recover approximately $7,500 per building, yet many of those buildings were likely only worth or were purchased for half that. Others, like Gilbert Ballin, were able to claim even higher returns. He received a $60,000 payout for a building he had paid just over $2,000 for a handful of years earlier. And there were few consequences to fear for this behavior. It wasn't until 1974, and more than $800,000 later, that Lou Wolf and Al Berlin were charged and found guilty for arson and defrauding their insurance companies. What was not included in their conviction was attempted murder, even though some of their buildings were burned while families were still in them. Instead, their sentence was 1.5 to 4 years in prison. It was also later discovered at least one judge in the housing court received financial favors from Berlin, which undoubtedly aided his avoidance of legal ramifications any sooner. But these weren't the only exploitations of government home purchase programs. There was another that resulted in one of the largest government scandals in history that cost the government $4 billion in the 1970s, which would be closer to about $30 billion today. The program was Section 223E. It was available to home buyers and allowed them to purchase a home with as little as $200 down, and the rest was covered by a mortgage, which carried no risk for the lending institution because the loan was insured at 100% by the FHA. To complete the purchase, the homes first had to pass FHA inspection, so there was no concern on the part of the home buyer or the lender whether the property was in sound condition. When put into practice, this program launched a new opportunity for exploitation. Not only did this program help contract sellers dump their dilapidated properties onto their contract buyers, but it also launched an egregious appraisal scam and spurred white flight much in the same ways government programs had in the 1950s. Solicitors bought abandoned properties on the cheap, or they scared white homeowners into selling below market value, again suggesting they'd lose their investment because minorities were moving into their neighborhood, which would decrease the value of their home. In time, FHA loans in a neighborhood became synonymous for Blacks and Hispanics are moving in. Once solicitors had possession, they relisted the properties for an amount higher than they paid and bribed FHA appraisers to overvalue the homes to ensure a worthy return on their investment. So, solicitors bought low, sold high, and the FHA guaranteed the loan for the lender, which meant there would be no major loss for the lenders if borrowers defaulted on these loans. Black and Hispanic homebuyers were enticed to purchase these homes through this loan program because the deal offered a low down payment and an FHA appraisal indicating the sales price was an accurate reflection of the home's value, or so they thought. The buyers were also led to believe their income was sufficient to secure the loan because solicitors completed the application for the loans for the buyers. Using inflated incomes, they hid buyers' debts and sometimes adjusted their family size, all to ensure the buyers would qualify for an FHA-insured loan. When the low-income purchasers inevitably defaulted, and often rather quickly, the lending institutions were able to collect the full amount of the loan plus 7% interest and inflated fees from the FHA, all part of the terms of Section 223E. With such favorable conditions for a default, lending institutions even pushed borrowers to default at times and had no incentive to accept late payments or modify loan terms. And while the contract sales market in Chicago created prime circumstances for such a scam, these occurrences were not specific to Chicago, but spanned the entire country, impacting neighborhoods in Los Angeles, Detroit, St. Louis, New York City, and Miami, and not just in neighborhoods with deteriorating buildings, but in some formerly well-kept neighborhoods. As the scheme progressed, the foreclosure rate on FHA loans became 7 times higher than on conventional loans. Eventually, the federal government caught on, and close to 500 people were convicted of fraud and various other crimes. But that didn't stop the scandal. Rather than ensure bad actors didn't continue bad practices, the government just adjusted the terms of the program. By 1975, for lenders to receive payment from the FHA, they had to properly secure and maintain the property, which they received payment per property to do. Rather than check this was done along the way, FHA didn't discover until much later many of these lenders simply collected the fee but didn't actually do anything to secure or maintain the properties, despite local FHA officials trying to raise the alarm. This left the federal government with countless worthless properties. Sadly, it wasn't just housing exploitation and the use of contract sales for home purchases that robbed Black Americans of wealth and preyed on their inability to access credit. For instance, there was a race tax beyond the real estate market. Blacks were charged higher prices for necessities such as groceries, medicine, and gasoline, without evidence higher prices in their neighborhoods was merited. To compound the wealth-depleting issue of contract sales in housing, goods and services, such as for accessories or for a child's music lessons, were also sold on contract and above market value with higher than average interest rates. What made this type of transaction for a sale of goods or services so destructive was the seller's ability to collect up to 25% of the debt out of the buyer's wages from the buyer's employer. This was particularly damaging in Chicago. In other jurisdictions, such as New York, the amount was capped at 10%. And of course, the process for the seller to collect the debt payment from a buyer's employer was incredibly simple. The seller just needed to request the buyer's employer pay the legally allowed portion of the debt to the seller from the buyer's paycheck. No court involvement was required. Additionally, most often in these types of sales arrangements, buyers waived all rights to defend future non-payment, mainly because this language was hidden in lengthy, complicated contracts for an otherwise simple purchase. Further, the law didn't require a seller to prove the amount owed, not even for matters that did go to court. Perhaps most damaging, this practice also impacted the buyer's ability to get or hold a job. Many employers did not want to be involved in dividing up their employees' paychecks, so the solution was to fire current employees with debt from these predatory contracts or not hire them at all. For someone like Reginald Kent, a client of Mark Satter's, this practice cost him everything. Not only had he purchased a building on contract for $11,000, he also purchased goods on contract, likely to ensure he had enough money to make his housing payment. When his creditors garnished his wages, his boss fired him, and he was unable to get another job because of the garnishment. Similarly, Robert Wilson and his wife purchased a refrigerator on contract and signed up to a club to receive some free food. What they didn't know is when doing so, they also agreed to a wage assignment. When they couldn't make all their payments, Robert's paycheck was garnished for what was owed on the refrigerator, and his boss threatened to fire him. Very little effort was made to address the predatory nature of installment contracts. Minor legislative changes were made only after a contract buyer took his own life because of the stress caused by the debt. In 1962, the Chicago Commission on Human Relations, also referred to as CHR, released a study that showed just how pervasive and damaging contract sales were in neighborhoods that had changed from white to black. But even with that knowledge and data in hand, CHR's only recommendation was to educate Black Chicagoans on the predatory nature of contract sales, which did nothing to address the overall issue, that there were few to no other options available to Black Chicagoans. Because homes on contract were so overpriced at the time contract buyers purchased them, home values never caught up, which is easily understandable considering Black neighborhoods already experienced prejudicial valuation. But installment contracts also prevented Black homeowners from being able to invest in their homes, make necessary repairs, and maintain aesthetics because so much of the family's income went toward contract payments. Consequently, this also stunted the economy, particularly for Black businesses that felt the direct impact of this financial scheme, as there were fewer dollars available in Black communities for goods and services. Unfortunately, some of these practices found their way back into modern real estate transactions because after the market crash of 2008, many Americans found it difficult to get approved for a traditional mortgage. Disproportionately affected were Americans of color. As we've continued to discuss, the disenfranchisement experienced by Black Americans covered all aspects of their lives, including their access to justice. Segregation and discrimination caused inequitable treatment at every turn. Thanks for joining us this week. We hope you enjoyed today's episode. If so, give us a like and don't forget to follow us on Facebook, Instagram, and LinkedIn. Please also subscribe to the podcast so you always know when new episodes are released, and leave us a comment and share our information with your friends and family. And remember, if you or someone you know is experiencing housing discrimination, or if you would like to schedule a fair housing training, contact our Fair Housing Unit at 800-875-8785. To see if you qualify for other legal assistance, contact the CLS helpline at 800-405-1417, or you can visit our website at www.legalaccessforall.org. We look forward to seeing you again soon.